Hello, everybody. We might get started. I hope you enjoyed a few sandwiches out there and are not going to be too sleepy as you digest for the next little bit. My name is Carolyn. I'm actually from the School of Computing and Information Systems, and I do my own research in the area of health data analytics and work with our Health and Biomedical Informatics Center here on campus. So I've been asked to introduce our speakers today who will be talking about health data and the legal context around health data. Let me start by acknowledging the traditional owners of the land on which this event is taking place, the land of the Wurundjeri people of the Kulin Nation, and pay respect to their elders and families past and present. I wanted to just give a little bit of explanation of where we are today. We are in the Victorian Comprehensive Cancer Centre. The Victorian Comprehensive Cancer Centre is a powerful alliance of 10 Victorian organizations that are committed to cancer control, and you can see them listed there at the bottom of the slide. And the role of the VCCC is to coordinate the collaboration between these member organizations and to develop a strategic program of work that integrates research, education, and clinical care to maximize patient outcomes in a cost-effective manner. And of course, we're sitting in a building shared with some of these partners, particularly the Peter Mac that's downstairs, providing that clinical care. We have in our Monday Lunch Live series a number of really exciting talks coming up, including Professor Nick Talley, who's a laureate professor who will be speaking on the 27th of August on the topic of publish or perish, which is very relevant to most researchers. Professor Jim McCluskey, who's the Deputy Vice Chancellor of Research at the University of Melbourne, and he's actually going to be giving us a research talk, which is great because I think Jim normally doesn't have the opportunity to geek out and just be a scientist. So I think he's probably going to have a lot of fun with that talk. So hopefully you'll come along and enjoy it as well. And then we have Miss Brigitte Smith, who will be talking about how to take medical research to the market. And I'm not entirely sure what that means, but I guess we'll come along and find out. And then we have yet another extremely important person, Professor Doug Hilton, who's the director of the Walter and Eliza Hall Institute, which is leading a lot of the research, particularly in the bioinformatics and molecular biology area across the way. And he'll be talking about our culture of medical research. So without further ado, I would encourage you to come along to these talks, but we're going to focus on our talk today. So I'd like to introduce to you the HELEX team. It consists of Associate Professor Mark Taylor, Dr. Jess Bell, Dr. Megan Prichter, and Dr. Carolyn Johnston. And they're joining us from the Melbourne Law School. Their new research program provides academic advice on law and best practice around the sharing and management of data generated from the use of digital technologies. And we were having a very inspiring talk over lunch, which I guess is a bit of a preview of what we've been hearing about today. And really, I think at the moment, this particular topic around health data and the legal context in which health data exists is extremely timely. Given the recent debacle around the My Health record, which I'm sure you are all very, very painfully aware of. And that, you know, from my perspective as a health data person, I really believe that health data has tremendous value. But of course, we can't be using health data for research purposes or even to help people with their own care unless we're sensitive to the context in which we want to use that data and we get their permission to do that. And those are lessons that apparently our government has not yet learned. So in the presentation, our speakers will discuss the recent changes in legislation and guidance that govern the use of health data by clinicians, organizations, and researchers. These include a framework for the secondary use of data from My Health record, the start of the Notifiable data breaches scheme, and the far-reaching effects of the General Data Protection Regulation. They will provide an overview of these changes, looking at both the legal framework and the evolving best practice. And I'm really looking forward to this. Help me in welcoming them. Thank you.
Good afternoon, everybody. It's a pleasure for the Helix team to be here today and to introduce ourselves to you and to share a little bit about our research. Let me introduce the team. I'm really the warm act. My name is Carolyn Johnston, and I'm a researcher in the Helix team. These are the rest of our group. So you can see that on the far left of your picture is Dr. Harriet here. She came over for 9 months and is gone back to Oxford now as the Deputy Director of the Helix team at Oxford. Dr. Megan Prichter, she'll be talking to you about My Health Record and other things today. In the middle we have Associate Professor Mark Taylor, who is the Deputy Director of Helix and directs our team in the Melbourne Law School. Jane Kay is Professor of Health Law at Oxford and the Director of Helix there. That's me, and Jessica Bell. And we have a PhD candidate, Tess Whitten, who is going to be looking at the adaptive regulation of emerging health technology. So what is Helix and what do we do? Helix is an acronym for Health Law and Emerging Technologies. Helix at Melbourne was established in Melbourne Law School last year in 2017 by Professor Jane Kay. And as has been alluded to, our research focus is looking at the legal and regulatory framework of health data, particularly around new technologies like stem cell research, gene editing, and so forth, with a particular focus on how these emerging technologies link with use of health data. We work very closely with the Oxford-based team, Helix at Oxford, which was established by Jane Kay in 2009, and also with our health law colleagues in the law school. In our first year at Melbourne, we were scoping out who's who does what, how we can become involved and collaborate with people in the biomedical precinct and beyond. And we look forward to working with some and more of you. Just by way of example, this is some of the research that we're involved with at the moment. So Mark is particularly looking at reasonable expectations of secondary use of data in a healthcare context. Megan is working with the Australian Genomics Health Alliance and this idea of dynamic consent, a two-way consent process. And she'll be talking to you also about her other mainstream of research around the legal issues in My Health Record, which, yes, has troubled us recently. Jess has been involved with information governance in the Melbourne Biomedical Precinct, and her particular interest around biobanking genomics and the Centre for Stem Cell Systems. And I've been focusing on wearable devices for children with type 1 diabetes and some of the legal and ethical issues involved there. And we've also scoped beyond our research and been thinking and been involved with some teaching programs. So the Breadth project, this is for undergraduate students in Melbourne University looking at on genetics, health and society. Some master's programs around genomics and health and the Melbourne Law Masters, and also getting involved with some elective teachings around health law and ethics on the JD program. So that's a little bit about us. We have a wide range of interests, and the team now are going to talk to you a little bit more about some specific areas of governance around health data and the way the law might be progressing here in Australia.
Thanks very much, Carolyn. I'm actually not going to be talking about how things might be progressing in Australia right now. What I'm going to say does have some relevance to Australia, though, which is what I'm going to go on and explain. The team is each going to cover a different area of law. Data governance law in general, to be honest, can at times be a little dry. So we decided we'd go kind of broad coverage rather than deep into a particular area of law. does mean if you do phase out at any particular point, don't worry, there'll be a new area of law along in a moment that you'll be able to zone into then. So yeah, I'm going to speak briefly about the General Data Protection Regulation and why I think it is significant to you and to Australia more generally. I'm speaking about it rather than Australian law. You might think, because I'm a European, recently arrived in Europe, in Australia from Europe, and so therefore I'm speaking about something I know about rather than that which I don't. I know something about it, but I'm recently arrived from Europe, and so I can bring a perspective on how GDPR has been affecting researchers in Europe and the UK in particular. I was the Health Data Policy Advisor to the Health Research Authority and helped the HRA craft its guidance to health researchers in the UK on how GDPR applies. So I have some understanding of the detail of GDPR as it applies to health researchers, but that's not what I'm going to focus in on now. What I'm going to focus in on now is why do I think it's relevant to you for me to be talking about a European data protection instrument. And we can then move on to consider the extent to which some of the standards set by GDPR are reflected in Australian law, or we can anticipate Australian law moving in the direction that will reflect these standards, or indeed are we moving away in Australia from the standards as imagined by the EU. Okay, so new 2017, it only came into force in May of this year, and a lot of the guidance that helps people to understand how the regulation actually applies in practice is still being produced. This is one of the challenges we had when we were writing guidance in the UK at sector level. Some of the national and international guidance wasn't established yet, which made writing the sector level guidance very difficult. So it is relatively new. Some of it is still being worked out at the level of detail and application at the coalface. But one of the things it did change was the scope of the application of European data protection legislation territorially. It extended the territorial application of EU data protection law. So it now applies whenever anyone, anywhere in the world is offering goods or services to EU members, EU citizens in the EU. So if you're offering services, including, for example, genetic testing services, to citizens in the EU, wherever you are, then the GDPR will apply. And if you're monitoring the behaviour of citizens in the EU, then the GDPR will apply to your processing activities wherever you are. So if you have a research project and some of your subjects travel to the EU and they're collecting data while they're there, they're perhaps wearing wearable devices, any processing of data in the EU or as a result of offering services directly to EU citizens will now be caught by General Data Protection Regulation requirements, irrespective of where the controller or processor is in the world. That's relatively new. There have some people have been concerned about this reach. As I say here, some non-EU entities in the health research sector, I'm quoting here from a publication that's forthcoming by a colleague, Ted Dove, who's based in Edinburgh. Some non-EU entities in the health research sector, including those in the US, have raised alarm bells about the impact of GDPR upon scientific research globally. They think that the application of GDPR requirements to human subjects research has alarmed people in the US national research community. They don't think the GDPR appears to have adequately taken into account the needs of scientific research. That's something that actually I would dispute, and Ted does dispute in this article. I think research is well catered for within GDPR, but if GDPR does apply to your processing activities, then it's best to understand how it does that. There are a number of exemptions within the GDPR that can apply to research. You have to know them to take advantage of them. So one of the ways that GDPR has extended its scope is through its territorial scope being extended, and now in some cases applying to processing of controllers and processors, even if they're not in the European Union. The other way in which the GDPR may apply to you is if you are receiving personal data from the European Union. And that's actually not new. That's always been the case. But data coming out of the European Union has to be flowing into environments that are recognized to provide adequate safeguards. The whole thing about the European data protection framework is it was intended to establish a minimum level of protection that would allow data to flow freely around Europe. But when they did that, they made sure that there were controls around data flowing outside of Europe into other contexts. So it can only lawfully be sent out of Europe by a controller in Europe if they can demonstrate the environment into which it will flow has adequate safeguards. Now, one way they can do that is just by saying well, it's flowing into a country that's been recognised by the European Union as a country to provide adequate safeguards. There is a list of such countries. Australia isn't on it. So you can't rely upon national law per se providing necessary safeguards. So the other way in which you can, or the controller in Europe who wants to send data to you, can demonstrate that is through demonstrating that there will be adequate safeguards in the environment to which you are sending data. The third way is if there is explicit consent to the data being sent outside of the European Union. But in that case, the data subject has not only to have explicitly consented to the proposed transfer, looking here at the italics at the bottom of the screen, not only have consented to the proposed transfer, but they need to have been informed of the possible risks of such transfers for the data subject due to the absence of an adequacy decision. Adequacy decision is the technical term for when the European Union says this country as a whole provides adequate protection. There isn't one of those, and they can't otherwise demonstrate appropriate safeguards. You can get consent to the transfer, but the consent has to be informed, and the people need to be told that it's being sent to an environment that may not provide adequate risks. If you haven't got that kind of consent, then you just need to be able to demonstrate to the controller that your environment to which they will be sending data does provide all the appropriate safeguards, technically, organisationally, and contractually. Okay, so when you're doing that, to what extent can you rely upon just the general legislative framework? To what extent does the general law in Australia help you? Well, that's one of the things we're going to consider as we move through some other areas of Australian law, current and proposed, describing to you what the changes are, and then reflecting back towards the end on whether or not this is a direction of travel that seems to be moving Australia closer toward or further from the kind of standards being set within the European General Data Protection Regulation at the moment. At this point, I'll hand over to my colleague, Megan.
Thanks very much, Mark. So I'm going to be talking today about two changes in the law that are new this year. First, notifiable data breach schemes, of which there are actually now 3 established in legislation in Australia, and these have some overlap and there are still some gaps. And also I'll be speaking about my health record, which has obviously raised a lot of controversy recently. I'll be focusing particularly on an issue for researchers, which is the secondary use of data in the My Health record. And this will be a really rich resource, but it's whether it will be a reliable and ethically gathered data source is another question. So first, as Mark has indicated, I'm just going to touch on the context in Europe. The GDPR includes notifiable data breach provisions, and these are quite stringent. They normally require notification to a supervisory authority of a breach within the first 72 hours of becoming aware of the breach, and notification to the people affected if there's a high risk that the breach will adversely affect their rights and freedoms. And the penalties, as you can see, for failing to notify about a breach are very high. There can be very large fines and potentially the requirement to stop data processing altogether. So turning to Australia, I said there are 3 overlapping Commonwealth schemes enshrined in law, and there's also a gap in the law, which I'll speak about in a moment. So essentially what the 3 schemes have in common is that if there is unauthorised access to or unauthorised disclosure of information or loss of information, then investigation, reporting to a responsible body, and potentially reporting to the people affected by the breach is now required under law. First, what is called the Notifiable Data Breaches Scheme. This is new Part 3C of the Commonwealth Privacy Act, and it came into operation in February this year. It applies to organisations that are subject to the Commonwealth Privacy Act, so Commonwealth entities, companies across all sectors, not-for-profits, and private healthcare providers ranging from major private hospitals to general practitioners to individual allied health providers. It does not apply to state-based public hospitals like the Peter MacCallum or research institutions that are state-based, so the University of Melbourne, for instance. Under the Notifiable Data Breaches Scheme, if there is unauthorised access to, disclosure or loss of information, and a reasonable person will conclude that the access and so on would be likely to result in serious harm to the person to whom the information relates, and remedial action can't remedy that harm, then they have to notify both the Office of the Australian Information Commissioner and the affected person. And they have up to 30 days to investigate the breach before undertaking these notification steps. The second breach notification scheme forms part of the My Health Records Act, which, as we know, is currently shifting to an opt-out system. So it is expected that by the end of the year, there'll be millions of My Health records, individual records in place. The breach notification in this scheme applies to every healthcare provider that is using the My Health Record system. So this could be public or private sector. And again, by breach, we're talking about unauthorised disclosure or use of information in the My Health Record. But here also an event that might compromise the security and integrity of the system itself. In some situations, the healthcare provider must notify the Australian Digital Health Agency, ARDA, or in other circumstances, they have to notify both ARDA and the Information Commissioner, and these details are spelled out in the legislation. There's a third scheme that I'll mention briefly. There are breach notification provisions in the National Cancer Screening Register Act that underpins the National Cervical Cancer and the National Bowel Cancer Screening programs. And in that case, notification goes through the Secretary of the Federal Health Department to the Information Commissioner. And as I mentioned, there are no comparable state-based laws, which means that data breaches in public hospitals and state-based research organisations are not subject to mandatory breach notification. There are recommendations about how to handle data breaches coming from the Victorian Information Commissioner, but these are not binding. And this leads to a bit of a messy picture, which I think does quite a disservice to people as they navigate the healthcare system. So here's an example, completely made up, of how the overlapping provisions in these different schemes might interplay in a specific episode of care. So imagine a patient, Ms. Smith, visits a private specialist, Dr. Jones, for advice about a health problem that is going to need surgery. Dr. Jones enters notes about her condition into the private clinic's record. Ms. Smith is then admitted to a public hospital for surgery as Dr. Jones' private patient. In the hospital, nurses and doctors enter information about her surgery and recovery into the public hospital record. Both Dr. Jones and the hospital also upload some information about Ms. Smith's treatment to the National My Health Record. So we've got 3 different sets of records about the same patient and the same episode of care. Imagine one of these records is hacked. So whether or not Ms. Smith has to be told that her data has gone missing depends on which record it was that was hacked. If it was the clinic record, there are mandatory notification provisions under the Privacy Act. The My Health Record, similar but not identical provisions under the My Health Records Act. The public hospital record, no mandatory notification. There's really great information about not only the Privacy Act scheme, but the My Health Record scheme as well on the Office of the Australian Information Commissioner website. There are substantial penalties for failing to notify the Information Commissioner and patients if mandatory notification applies under the Notifiable Data Breach Scheme and the My Health Records Act. Penalties of up to $2.1 million for a corporation for an act that is judged to be a serious and repeated interference with privacy. However, particularly as the Privacy Act scheme is new this year, the Information Commissioner's Office has said that they're going to take a supportive and educative approach to managing, helping organisations manage data breach notification. And so I think we're unlikely to see any fines for some time. The website also has Information Commissioner's quarterly reports on the operation of the new Notifiable Data Breaches Scheme. They show that the health sector is the largest source of breach notifications. Around 20% of all notifications are from the health sector, and most of these are due to human error rather than hacking. Given that this does not include the public hospital sector, I think these numbers are rather concerning. So whether or not you and your organisation are required to report breaches by law, I'd encourage you to consider good practice in this area. Consider what you can do to avoid security breaches in the first place. If a breach does occur, can it be contained? Can passwords be changed or breached accounts locked? If you are required or choose to notify affected people, consider how best to do it. And again, the website has really good guidance on this. They'll need to know not just what has happened, but what they can do next in order to protect themselves. And if you aren't required to notify, still consider if it's in the best interests of patients and good practice to do so. To touch on the context that Mark outlined, I think Australia is lagging behind Europe in this arena, which obviously has much shorter timelines for investigation and higher penalties. So it would be interesting to see if the trend in Australia is to tighten things up in the future, and also to introduce legislation in the states to make for a unified system, which I think would be great. Also, just bear in mind that if you are processing data on behalf of someone who's based in Europe, in the event of a breach, the person in Europe, the data custodian there, may ask for your assistance in managing that breach, and be aware of the much shorter timelines that apply. So I'll turn now to the second big new thing in terms of health data in Australia this year. The My Health Record is not in fact new. It was introduced in 2012, but has been in the news a lot lately because it is transitioning from an opt-in system to an opt-out one. So unless a person is opted out by mid-November, they will be given an individual My Health Record. This is an online record that is a copy of records held in a variety of other systems, so Medicare, PBS, pathology and imaging reports, vaccination records. It also contains shared health summaries that are uploaded by a GP, information from hospital discharge letters, and data entered by patients themselves if they wish. So while I'm not going to focus on the record itself today, I did want to say that there have been a range of concerns expressed about it. These include access by law enforcement and other government entities, which was originally possible without a warrant. The legislation is now going to be changed so that a warrant will be required. There's a risk of data breaches for this very large data set containing very sensitive information and many points of access. Issues of privacy and issues of usability and equity, IT and health literacy coming to the fore. And moving to opt-out certainly raises ethical questions about informed consent, particularly as the privacy settings that are the default settings in each record are set to be quite permissive, and to make them tighter, people actually need to know they have a record, access it and change the settings. However, today I want to focus on an issue that will be front and centre for many researchers, that is the secondary use of data contained in the system. So under the legislation, one of the functions of ARDA, the Australian Digital Health Agency, which operates the system, is to prepare and provide de-identified data for research or public health purposes. The release of identified My Health Record data is also possible with participant consent. ARDA has undertaken a broad consultation in regard to a framework for secondary use, and the framework was released a few months ago. The Australian Institute for Health and Welfare is the designated custodian of these data, and no release is planned before 2020. Any Australian-based entity except insurance companies will be able to apply to access the data. The data can't be accessed solely for commercial use, nor for non-health related purposes. And the system will rely on the 5 SAFEs principles, which my colleague Jessica Bell will speak about further in a moment. The data must generally be kept in Australia, although there's a small amount of wiggle room in that regard. And the data can be linked with data from other sources. So when it was decided to transition the whole My Health record to opt out rather than opt in, unfortunately, in my view, the default settings for people's choice about secondary use were also set to opt out. So this means that people's de-identified data will be available for secondary use unless they go into their record and change the settings. This has been rather poorly communicated in my view, and I don't think it's very good practice. Given that many people will be unaware that they even have a My Health record, let alone that the data from it is flowing into secondary research, it's problematic. I think there are also concerns about the risks of re-identification of data. We know from the work of Vanessa Teague, Chris Cullinane and others at the University of Melbourne that supposedly de-identified data may be quite readily able to be re-identified. And particularly here, as the data can be linked with data from other sources. There have in fact been some moves to criminalise this re-identification, with a bill introduced into the Senate in October 2016, but that bill has not progressed. It seems unlikely to, in my view. Finally, it remains to be seen whether the My Health record data are sufficiently robust to have appeal to researchers, given that they are really quite a limited copy of someone's main health records. However, despite all their shortcomings, this is going to be a huge and potentially very valuable resource for researchers who can use it to improve Australians' health and wellbeing, and it'll be really interesting, I think, to watch this space. I'm going to hand over to Jessica Bell now, who's going to speak about a brand new bill on data release and sharing.
Thanks, Megan. So you've heard the pressing stuff. This is a bit of horizon scanning. So if you do tune out, don't worry, because it's not happened yet. So you can keep an eye out when it does actually, when it does go forward. So I'm going to talk to you about the data sharing and release bill that's going through a public consultation and drafting phase at the moment. This is a piece of Commonwealth legislation that relates to the access to public sector held information and sits on top of existing regimes. So this is part of a suite of reforms at the Commonwealth level in terms of data sharing and release, so access to public sector data. The Productivity Commissioner did a review of data use and availability in Australia, and in response, the Australian government committed to a number of things. They committed to establishing a new National Data Commissioner, to introduce a piece of legislation that would improve the sharing and use and reuse of public sector data, and a new consumer data rights, which I'm not going to talk about today because it's dealt with by Treasury, and until last week the bill wasn't available, but actually now the exposure draft has been released, and so there is information out there now on what that new consumer data right will look like. But this particular piece of legislation is going to be the subject of my talk now, and the legislation actually represents a real shift from a more restrictive approach to data access to a more permissive approach that kind of takes as its assumption that the data should be available and subject to certain conditions. So it's there's a reason why it's important to watch the space, because I think it does represent a move to this greater availability, which would be a great resource, a great research resource. And so, as I say, this sits on top of what exists already. So there is access pathways that exist at the moment at both state level and Commonwealth level, subject to the Privacy Act at Commonwealth level, for example. So it's not that you won't necessarily have been able to access this data before, but it was felt that there needed to be easier, more accessible ways to get access to the data. And so currently, as it's drafted, this sits on top of everything that is already in place. And the idea is that actually, if you potentially didn't get a yes before, this might create a pathway that means you can get a yes to access that data now. Somewhat controversial, it's in its early stages of drafting, and the University of Melbourne and indeed the group, the Helix group, have been involved in discussions via roundtables, etc. on the bill. So we're keeping a close eye, but a bit more detail about it then. So the scope of the data that's covered by this new Act will include all data at the moment, so including data held by, including both health data and administrative data. And this relates specifically to Commonwealth held data, so data that's held by Commonwealth entities like Medicare and MBS data, and Australian Bureau of Statistics and the census data will both be included, and Commonwealth companies, so including the Australian Digital Health Agency and therefore the My Health Record data that Megan has spoken to you about. And as I say, it covers at the moment both administrative data and health data. I think there is parallel regimes at state level that sort of relate more specifically to administrative data, and I do think this is the kind of underlying reasoning for the new Act, is to make that kind of administrative data more readily accessible. But as I say, so this is all data, so administrative data and health data, and it relates to all types of data, so identifiable and non-identifiable. And the approach that is taken is a risk-based approach, so a kind of proportionate view of, depending on the type and the sensitivity of the data that's available, then there'll be different controls and different levels of the information. So there'll be both the identified and identifiable information available. And the reason it's called the Data Sharing and Release Act is because both public release, so kind of general publication of large de-identified aggregated data sets, will be available kind of by default and publicly, as well as kind of dissemination of controlled data access at the more kind of individual level, at a de-identified and also identifiable level. And so it takes this kind of sliding scale approach to the controls and the sort of data that will be available. And so in order to get access to this data, currently there is a two-step process that will be required to be met. So first and foremost, it will need to sit squarely within the purposes that are foreseen by the Act. And the purposes, as currently drafted, include straightforward government policy making, provision of government services, the development of government policy. But there is also a specific purpose that's been written in on research and development with clear and direct public benefits. And I think there will be, it is anticipated that public benefits will be defined within the Act. So there'll be an interesting demonstration of what public interest or public benefit research actually is in a quantifiable way in that Act. So worth keeping an eye out for that. So that's the first step, one of the purposes, and then the second step will be subject to the safeguards that are the 5 safes that Megan introduced just before. So the 5 safes are internationally used, so they've been used in the UK, they've been used in New Zealand, so they're quite well known and well used. They relate to 5 different levels of safety, so safe data, safe people, safe settings, safe outputs, and safe projects. And the idea, as I was saying before, is to kind of have a risk-based proportionality sliding scale approach to the level of data that's available and under what conditions. So the more risky or the more sensitive the data is, the more strict the controls will need to be, and the more the different environments will need to be designed to reflect that sensitivity, etc. So if you're having a request for individual level personal data that's identifiable, obviously you're going to need to be able to demonstrate very safe data, people, settings, outputs, etc. But one of the things that I think will be really interesting, and I'm just skipping ahead for the sake of time, but the University of Melbourne and the Helix team are going to think about with the Melbourne School of Government actually just what that 5 safes means in the context of University of Melbourne research, and potentially developing a protocol that will help individual researchers and data custodians think about what the 5 safes means in the context of our university and our kind of research context. So we are interested in thinking about that further. And so they're the 2 levels. You'll need to satisfy the purposes test. You'll need to satisfy the safeguards requirement. And when I say you, I'm talking about who decides, the data controller, so the data custodian, the people that hold the data. When they're making a decision about whether to make that data available, they will need to satisfy the purpose, the safeguards, etc. And so we're putting responsibility on the data controllers to meet the purpose test and the 5 safes, and to make a decision about whether public release, whether controlled data sharing, or whether access denied will be most appropriate in which context. And those data controllers will be, public sector departments, etc., and they will be able to outsource under the Act some technical expertise. So they will be able to, for example, hire service providers to de-identify data to make it available, or to link and combine data sets. And the sort of oversight that sits on top of this Act is via this National Data Commissioner, who is this new organisation, this new office that is being established. And they, the National Data Commissioner as an office, will be advised by a council that will be comprised of experts. There was an expression of interest that just closed recently, so those experts are being recruited as we speak. But the National Data Commissioner, as I say, will have oversight of the legislation and provide guidance. So it's quite likely that there will be briefing documents or guidance documents that are available on specific topics, potentially saying public interest and the meaning of public benefit. So it's worth keeping an eye out for the National Data Commissioner's website when it does get up and running and is populated. And yeah, I think that in terms of the GDPR, what's interesting is that we would hope that this creates across the Europe and Australia level, this sort of regime that's envisaged by the new Act creates a kind of harmonized approach to very kind of safeguarded, proportionate data access that that kind of takes into account the granularity of different levels of data and the appropriateness of certain safeguards and controls. And we'd expect that there would be some kind of harmonized approach between definitions of, say, de-identified data in Australia and definitions of personal data in Europe. So we hope that this sort of signifies, and we'll hope that the eventual drafting will signify a harmonized approach. If you do that comparison, data custodians will be data controllers under the GDPR, and yeah, there will be accountability mechanisms in place that kind of map out onto the general data protection requirements, which Mark will just summarise on now.
Okay, thanks, Jessica. Okay, we were talking about law, and we were talking about data governance in law. It may not have felt like it, but that was a whistle-stop tour of some of the recent developments, either new law or existing law being implemented or developed in particular ways. What draws all of that together is the fact it is all new. It shows just how quickly areas can change and how complicated areas can get. I think if we were able to establish what the 5 safes meant within the university environment, if we could document that according to good practice internationally, then that would help tremendously when it comes to ensuring that in any given context you are meeting the notification requirements as they are now applicable within Australian law, that you're meeting the requirements of appropriate safeguards if you want to get data from Europe, that you are establishing within university context the conditions for trustworthy governance that are going to protect you from the kind of concerns that are currently being levelled at My Health Record. But one of the things you can see, if you look across data governance internationally, one of the things you can see is an increasing trend towards data custodians, controllers, being held accountable for their governance practices. They're increasingly putting the responsibility, the accountability for good practice on the controllers themselves. So if you are responsible for information governance within your own organization, do you have any responsibility for it at all? And I should imagine very many of you are responsible in some way for the handling of personal data relating to others. Then to what extent does your organization have a good map, an asset register of its personal data? Have the data assets been mapped? Have the data flows both in and out been mapped? Do you know what the legal basis is for the data coming in and for going out, and the legal basis of holding it while you have it? What is the intersection between your systems and other systems such as My Health Record and with other jurisdictions? Both the state and the Commonwealth relationship has already been mentioned. We know that it can be complex, but with other countries too, including with Europe. If you can map all of that, you can understand its relationship with good practice, and you can articulate what the 5 safes means for you with regards to your own information handling practice, then I think you're in a good place to establish that you have the kind of trustworthy governance that we need if we want people to continue to trust us with the sensitive data in years to come. Okay, so we are, as I said, that was a whistle-stop tour. We are here now to try and focus in on any areas that you are particularly interested in. Can I ask other members of the team just to come up to field questions, please? Thank you.
Thank you.
So if there are any questions,
I think the map, and I thank you for you've had a very precise definition of the GDPR and who it affects. If an EU citizen is being treated here, does the GDPR apply here?
No. So it only applies to an organisation outside of Europe if they are directly targeting their services at EU citizens in Europe. So if you were to set up a web page where you were deliberately marketing your services to European citizens, then the processing of their data insofar as they're interacting with those web pages would be caught by the GDPR. When they're actually here in the territory, it's the local domestic law that would apply.
Talking about secondary use of data from the My Health Record, de-identified data, what is the genomic data? Can it ever really truly be considered de-identified? And what about, you said it generally won't be able to go over Australia. Well, researchers are uploading copious amounts of genomic data onto our open access repositories online. So how does this work with the current law?
Yeah, I think that's a real concern. So there's something in the media a couple of weeks ago about genomic data, and ARDA had actually paid another company to build the system that would upload genomic data to the My Health Record. And I think the answer is yes. There are real concerns about whether it can ever be really de-identified. I think from memory, Minister Hunt's office said, oh, it's just like pathology reports. Well, it's not just like pathology reports. It's substantially different, we would argue. And yes, there's a lot of data sloshing around anyway. So even if it's finally control this little system, once it's out of My Health Record, obviously those controls don't apply anyway. So no, you'd be quite absolutely right.
See that in the back?
There was something about if the doctor or a vet upload information about not the patient, but a relative of the patient, that data would be gathered.
And that applies specifically to social media, but it's about issues.
Well, the Privacy Act does make provision currently for that kind of data about relatives of individuals under care, and then obviously under the NHMRC guidelines for the research use of that kind of data. So it's not completely uncharted territory in terms of how that will be managed. I haven't seen any specific guidance on that.
No, I
particular
haven't.
issue.
I haven't either. But I mean, again, I suppose similarly to the question about genomic data per se, yes, it has implications for family members. And so if it's uploaded to someone's record, I can imagine the situation you're describing. It's also important, I suppose, to remember that people can delete documents from their board, turn them off from their record once they've been uploaded, or restrict access to them. So if they have concerns about a particular thing that's gone onto their record, they can have it removed. They may not know. Yeah, exactly. Yeah.
I think a lot's still being figured out.
Yeah.
It's
But particularly in relation to secondary, you're speaking about secondary use of my health record data specifically, or
Specifically in the privacy section.
Yeah.
It asks that a secondary person nominate your name on a letter. They will that information.
yeah.
Also about their business consent.
But I mean, we are just over the road. if there are specific questions that are applicable to an area, all of the areas we've been talking about today are new, and that some of the detail and its application is still being worked out. I mean, do get in touch, and we'll be very happy to work through some of these issues with any one of you.
And they are exactly the kind of issues that we're sort of monitoring in the group. So I guess just having an ear on the ground in that respect is something that we can say we're doing. And and being able to hear about those specific concerns helps us understand better, you know, what to focus on. Thanks.
Sidewalk question, but I was just wondering, what's your perspective, or do you hear that the emphasis on privacy and the focus is being put on that aspect of, when it comes to, say, health data in particular, that we potentially run the risk, given the current sort of state of play and how things are actually kind of happening, that we actually generate such a risk averse and potentially legally preventative landscape that we actually then prevent the ability to capitalize on the collective benefits of actually using data that we currently don't actually have. And that you look at things like data.gov that happen in the UK, and that's like sort of massive. You know, that's probably set from their research back in 20 years. Do you sort of, given that we're not necessarily talking about these issues in other areas where they potentially are more relevant, say, about social media and companies and Google, the emphasis that's then placed on this in the healthcare sector, where we then become very protective as if there's, you know, we should encourage maintaining high level sort of focus. Like, what's your perspective from the legal sort of sense in relation to that, given the current reality at the moment?
I think if I go first and chip in, I think privacy is not necessarily best understood to be equivalent to or equate to secrecy. Privacy is about respecting people's data and respecting their choices in relation to their data. It's about respecting their, what I would describe as reasonable expectations of the data use. People often want their data to be used. They don't want it just to sit on that person's desk and never go to somebody else who is also interested in their care or could also do something valuable with it. People generally want data to be used, but they want to be able to trust its use. And so I think what we need to do is ensure that when we're talking about privacy, we are talking about establishing the conditions under which people can trust that data will only be used and will be used in ways that they would consider to be appropriate and reasonable. And yeah.
We don't actually emphasize that aspect of it. We emphasize the need for safeguarding and stopping, and that actually that sort of message isn't actually getting through. I think
Yeah, no, yeah, but
your exact message isn't actually that what necessarily communicated.
I was in the UK when the care.data thing that you were talking about was in the headlines. And one of the challenges that the people who were responsible for the program faced at the time was they could not point to the guarantees that people wanted to see that the data wasn't going to be misused or abused. So you need to be able to say to people, your data will not be used for these purposes. You need to be able to provide the guarantees associated with it in order to give people some kind of, if they ask the question, you have to have the answer. How do we stop this, the inappropriate use? So that it doesn't need to be there, but I do agree. I think fundamentally I agree with you. In providing that assurance, we mustn't over-promise or indeed offer guarantees that if you had the opportunity to sit down and talk through with someone, they wouldn't even want, because they want the data to be used appropriately and they don't want to see it locked in a safe and never used for any purpose whatsoever. There's no value in that for anyone.
Because the reality is when you look at what breaches do occur, even though there are a lot of breaches, a lot of them are human error and system functions.
Yeah.
They're not malicious, they're not malicious intent. And so for a lot of people think about commercialization of their data, which feels like the biggest sort of key point. It's basically kind of, I just fear that we potentially run the risk of sort of risk-aversing ourselves into a situation where we're dealing with these aspects in a sector that is because we have the only, what we can actually act on. Yet we're not dealing with them in relation to the bigger picture things that are actually the reality of where our data is actually being captured by it. And that's not being addressed by legislation. So how do we have any trust? How do we have these parallel, these two parallel worlds where Google knows everything we do and maybe they can pay. Yet your GP and your hospital can't communicate with each other because we can't. So we don't know the systems, we won't invest in the technology. We're still thinking about the framework on the legal side. Yet at the same time, Google and Facebook are walking around doing whatever they like. So how do you generate trust in that sort of environment?
So Miguel will comment on that argument as well.
I think I'd agree that the communication around my health record has been very much on the kind of risk pricing side, and there's not been so many voices saying actually we really need this as patients. It's driven by a real need for information sharing, particularly people with chronic health conditions or who are managing the care of elderly relatives who are on really medication. This could be really valuable, and so as Mark said, it's important that it be rolled out responsibly and carefully, but it's not. I don't think it should be just tossed out because of the privacy concern.
And the exceptionalism that I think attracts, just a last point, the exceptionalism that I think health data attracts is, directly relevant to the trust point. People feel that the stakes are higher, and so that trust is harder to kind of garner and nurture. But certainly in Helix, I'm involved in a project that relates to the use of tracked Wi-Fi data around campus, and I'm trying to be involved in having a kind of engagement exercise that means that those sorts of projects are thinking about exactly these issues, not just the ones that are thinking, dealing with health data, because it's all information that people have an opinion about being collected. So we don't want the message to be that, certain categories of data are so special that we have to just pile, risk-based approaches to it. But we're thinking about engaging just across the board with data users and how they are all regulated and dealt with.
Sorry.
Well, yes, it's sort of.
I just wanted to, it seems to be great research coming from collective health data coming out of Scandinavian countries, and I wondered what your comment is on those, have they got it right, and what can we learn from them?
Well, I did a bit of work on the Estonian biobank and the Icelandic biobank and the Norwegian hunt study. And I think one of the things that those studies have in common is that they have these quite different cultures, right? So that the individuals about which the information is collected is very, very different to a country like Australia, where there's just more diversity, it's harder to manage, the countries are kind of taking their own approaches. And so I think context matters in those projects. That would be my comment.
So I think that there are things that can be learned, but they're principally about why do people in those environments tend to have a high level of trust in the government or commercialisation. So, and there is a certain history associated with that, which unfortunately we can't design into a specific project.
Okay, we might leave it there. Let's thank our speakers.
Thank you.
Yeah.